African Women in Arbitration is now paving way for professionals to excel in the field of arbitration by creating more inclusive and dynamic field of dispute resolution, as the Executive Director, African Women in Arbitration Edith Twinamatsiko explains.
We're encouraging women to come up and be trained. Yeah, it's not just to promote. You have to have the competence. You have to have the skills. So that's why we go ahead and organize this training session. So after training you, what next? We take you through a mentorship journey. Work with someone who's already established. We all know that in this arbitration area, you need to have a network of people to recommend you for appointments and so on. So mentorship is very important and dear to us.
This was during a 2-day African Women in Arbitration training and symposium that convened experts, practitioners and policymakers at Serena Hotel in Kampala, under the theme, Driving Africa's Energy Transformation, the Role of Arbitration in Advancing Africa's Green Future.
I encourage women practitioners, or those who are passionate about the area and they don't have the skills yet, to attend such events, get perspective. But if you're already passionate about it, the better. Come, network, meet fellow practitioners. If you're not skilled yet, you can check our website, the number of trainings that come up, and follow us on all social media platforms and see how you can elevate yourself in this line of arbitration.
My name is Mariam Nansamba Iga, an arbitrator and a non-lawyer. I stand as a poster child for non-lawyers who are involved in the justice ecosystem. In the justice ecosystem, outside the known court system with all its benefits and challenges, is alternative dispute resolution, where arbitration is at the tail end, but where we have the other mechanisms like negotiation, conciliation, neutral evaluation, mediation, that would be very, very, very helpful in ensuring that justice, one, is not delayed or denied, but most importantly, justice that preserves relationships. Alternative dispute resolution, where arbitration falls, is a practice where even non-lawyers can be part of the system. Engineers, architects, quantity surveyors, anybody who has piqued interest outside their professional line can start on a journey to be part of what I call the appropriate, because ADR is no longer an alternative to the litigation system, it is the appropriate. We've been asked times without number, why do we think women are left out in the big deals? It is not because they are not able, it is not because that the system doesn't allow them, but it's because we have reached a state, I'll speak from the positive side, where such avenues like ADR, and I insist that A is appropriate dispute mechanism, creates a stage where as long as you have trained, you have the credentials, the world is your oyster, you're just starting. So my encouragement would be to, especially the non-lawyers, because I think the message has been wrongly been sent out that anything to do with justice has to be with litigation and with lawyers. So I just call upon the non-lawyers who are interested in being part of justice to pick interest.
The General Secretary, National Union of Lawyers, Judicial Officers and Allied Workers, Penina Tukamwesigwa, called on Ugandan courts to promote alternative dispute resolution to reduce on-court backlog.
Yeah, arbitration really, it's a general problem in Uganda. There's backlog of cases everywhere. So the moment you use any method, any alternative dispute resolution like arbitration settle cases, automatically cases will go down because people will choose They have arbitrated, and it's more speedy, more efficient, more effective than waiting for a hearing, waiting for a motion or a hearing where it's up to the court to decide whether the judge will sit or not. If it's court recession, you cannot proceed with your cases. There are so many turbulences being in court than when you venture for these alternative dispute resolutions like arbitration.
Experts called for reform in the bilateral investment treaties to conform to the international standards.
One of the avenues we could use as a means of reducing our vulnerability to climate change is by using bilateral investment treaties. So bilateral investment treaties, in essence, they are tools for mitigating the impact of climate change. However, the challenge that we have is that they are relics of colonial era. They lack substantive provisions or innovative provisions, such as those that we see. For example, I gave the example of Australia and the UK bilateral investment free trade agreement. The example of the Turkey United Kingdom free trade agreement of 2020. And even our recent African Continental Free Trade Area agreement, where we have an investment protocol that has a section that deals with issues around sustainability and climate change. So we need to modify our treaties to align with such interests.
Particular challenges faced are sanctions often prevent representatives or respondents from adequately accessing justice, appointing legal counsel, paying legal fees and expert fees. These pose a lot of challenges to the formation of an arbitral tribunal. The other challenge faced is that you can have delays in securing evidence and preserving it during the process of arbitration. Often you cannot access a site because of the security implications. You cannot go to site during a conflict zone, and yet you need evidence to be collected at site, or you need the tribunal to understand the situation on the ground. That means you need more flexible ways of collecting and securing evidence.
Experts emphasize the need for African governments to move beyond political declaration and demonstrate tangible leadership by integrating climate justice into national budgets, legal frameworks, and development plans.
So the main ways we mitigate are the use of technology. For example, you can have hearings by video conferencing. You can have witnesses who may be too scared and have had to leave the conflict area to give evidence remotely from a secure location. You can collect evidence and upload it using some software that preserves it in a secure format in a way that prevents it from being tampered with. So technology can be a big enabler. However, we must also be careful that technology does not allow confidential data to be accessed by third parties.